Okay.
All right, good afternoon. My name is Lisa Hogel. I'm the director of the OSHA Education Center at Arizona State University, and want to give you a thank you for joining us on our Regional 9 Education Center collaboration with the region. And being from Arizona, I just have to give a shout out to congratulations to all of those here in Arizona with me who experienced our record-breaking number of days over 110 this past couple of weeks. You survived. And as I pass the microphone to my colleague Raul to introduce himself, I just want to leave you with a reminder that we all need to stay hydrated. He is still an issue out there for all of us, and to be aware of that as you're out there working. Raul?
Thank you, Lisa. Hi, my name is Raul Guzman. I'm the director of the OSHA Education Center here at the California State University Dominguez Hills. And what I want to share with you is that we are back in person. So all of our classes are back in person. So we can't wait to see you in class. Thank you.
Hi, folks. This is Stephanie Spann from the UC San Diego OSHA Training Institute Education Center. I am very fortunate to be living in San Diego without the hardship of my colleague in Phoenix. So not Trobit and Lisa, but it's a little cooler here than at your home. But we want to welcome you. This is another event that we are hoping catches your attention. And I believe we do have a great format for you. And Anissa will be going over that format and kind of the housekeeping items as well. So take it away, Anissa. Thanks, folks.
Thank you, everybody. Welcome to our session today. We will be getting started with Mr. Matthew Parra, who is with the OSHA Whistleblower program in just a moment. But before we get started, I just want to jump in and review the Zoom controls. So this session is being presented in a webinar format. You don't need to worry about connecting your microphone or your camera. However, we want your participation, so please help us address your needs and your questions. Please use the Q&A button at the bottom of your screen if you are joining us from the Zoom desktop app or web browser or mobile device. In the upper right corner of your screen on your mobile device, you will also find additional Zoom controls. Please ask your questions in the Q&A panel rather than in the chat panel. Once you click that Q&A button, a dialog box will open, allowing you to type in your question. So in that chat panel, we will be providing helpful links and other information. And our Region 9 OTIEC coordinators are standing by to assist you. We'll be answering most of those questions at the end of the session, although Matthew welcomes your pressing technical questions that can be answered at appropriate times during the presentation. So with that, I'm going to go ahead and turn it back over to the team.
Okay, I guess that means I'm up. As mentioned, I'm Matthew Parra. I work for OSHA. I'm here out of the San Diego area office. So like Lisa, I'm enjoying lovely San Diego, where it's not 115 degrees, but you can certainly get a nice tan and sunshine here in sunny Southern California. I want to start off by thanking each and every one of you for taking the time to log in and learn a little bit more about something you may not have heard a whole lot about before. Another aspect of OSHA that really doesn't necessarily get center stage and discussed. And so please let me know if you have any questions or concerns throughout the presentation, but understand that I really just want to start from a position of saying thank you very much for taking the time and caring to log in. A bit about myself. I'm born and raised here in San Diego. I have over 34 years of federal service, and that's combined between military with the U.S. Navy and civil service. This is my fourth federal agency, and I've been a lawyer licensed to practice law in Maryland, where I went to law school, since really 2001. And so I came to work for OSHA about 1.5 years ago, and really had done employment law for almost 20 years between the U.S. Coast Guard and the Department of Homeland Security's Transportation Security Administration. And so I was very familiar with Title VII retaliation type complaints, but not familiar with OSHA's. And so I wish somebody had given me this presentation back when I was trying to interview for the job, certainly, because I think it's a very good foundation to try to understand really how much and what the whistleblower program does for OSHA and for workers around the country. So enough about my background. What I'm hoping to accomplish is really to impart upon you that OSHA's whistleblower program engages in a wide range of activities, really in partnership with employers, employees, and state plan agencies to try to achieve OSHA's mission and goals. And that mission and goal is really ensuring workers have the right to exercise their rights regarding a safe and healthy work environment, free from the fear of retaliation. So the presentation is going to be that overview of the program itself, all of the activities and experiences that we do nationwide, but also here in Region 9. And you're really going to get a chance to see what a basic whistleblower retaliation complaint looks like, what that process for investigating a complaint is, and the important roles state plans play in that, and even some best practices for employers on how to implement anti-retaliation programs, with a few other topics thrown in. Really, the three key takeaways are: workers have a right to report safety and health concerns, free from the fear of retaliation. OSHA partners with state plans to provide a broad coverage of whistleblower protection laws, not just for safety and health. And then finally, OSHA endeavors to accomplish worker protection through outreach, just like this. This is an outreach event. And I want to thank, the education centers for really giving me an opportunity to come, augment, what you may be learning in the classroom, and hopefully provide you with something that otherwise you might not get. Okay, with that, as an introduction to a further introduction to what we're going to discuss today, the first thing we're going to talk about is workplace retaliation. Then we'll cover a little bit about who is covered by the OSHA statutes, what does OSHA's whistleblower program do in detail, and then the elements of a whistleblower complaint. And finally, we'll talk about some challenges that our program faces. So what is workplace retaliation? Workplace retaliation is any time that your employer, through a manager, supervisor, any other type of person that can be considered part of the employer, takes some sort of adverse action. Typically, it's firing. That one's the easy example to give. But really, it's kind of anything that could reasonably be considered negative, and really that would discourage you from reporting safety or health violations or other types of violations. Those would be considered adverse actions. And we'll talk about more examples of those and how we sort of look at the facts of each case to determine, if there is a material adverse action. But basically, if an employer is trying to do something to prevent you from blowing the whistle on some sort of unsafe or illegal behavior, that's what workplace retaliation is. And it's different from the type of retaliation that you might be more familiar with, such as sexual harassment or something of that nature, which is really more a matter for the Equal Employment Opportunity Commission. The EEOC handles those types of retaliation complaints. OSHA handles workplace retaliation. And so your basic right as an employer is that employee is that An employer cannot take retaliatory action against you for exercising your rights. OSHA's whistleblower statutes cover a variety of industries and services. In fact, you're obviously familiar with the OSHA Act and Section 11C, which is the safety and health component of it. It was what created OSHA. It's what most people think when they think of OSHA, they think of safety and health, right? But when it comes to whistleblower retaliation protection, OSHA actually has 25 statutes that we're responsible for enforcing. And so those statutes generally fall into the following subject areas. Of course, employee safety, but transportation services, environmental protection, fraud and financial issues, consumer product, motor vehicle, and food safety, and then health insurance. So not all of these are safety-based, but the common theme is that if you engage in trying to point out some sort of wrongdoing, illegal conduct, or unsafe condition, you have the right to do that without being retaliated against. And if you are retaliated against, then OSHA is responsible for coming in and investigating to determine, what, if anything, we need to do to try to remedy that situation. So the statutes are summarized in a chart that's available to the public online at whistleblowers.gov. And the reason why I like to mention this, and I like to include this in the presentation, is because many people have no exposure to the exact statutes and how they work. And so this one summary chart is the best tool, in my opinion, for you to go to and see, well, is it possible that this situation may apply? And as we saw on the previous slide, really the statutes can kind of be grouped by industries. And so if you happen to work in a particular industry, whether you're just an employee or you're a safety professional trying to, build a model safety program and advise your employer on how to ensure that your work environment is as safe as it can be, understanding the different statutes that could apply to your particular industry is really important, because it is important to ensure that your employer pays attention to the nuances of each statute and the different types of remedies and other factors that apply, including the appeals process. So in this summary chart, it's all laid out for employers, safety professionals, even employees to take a look at and see, what really is OSHA's jurisdiction, and which particular industries and are there rights against retaliation. So I always include this slide on the summary chart in order to ensure that that it's out there for you, and that's there's other guides that are available at whistleblowers.gov that can tell you even more details about coverage, jurisdiction, and how these statutes work. But the initial stop for me is always the summary chart. So what does OSHA's whistleblower program do? Now that we've kind of taken a look at a worker's basic rights and some of the issues associated with a whistleblower retaliation complaint, really it's important to understand that the OSHA whistleblower program engages in a lot of activities that aren't just investigating the complaint, but certainly that's our number one primary responsibility. And we will get into the process that we go through when we receive a complaint, all the way through to when we make a determination and, if necessary, order remedies. But there are other things that we do that are important to know, especially if you're a health and safety professional. And one of the things that we do is we assist in monitoring state plan whistleblower programs. So we actually regulate the state plan programs. And that's a very different role than most federal agencies are involved in. And so state plans investigate complaints under their version of 11C. But we're the ones who basically approve their program procedures, and then we assist and guide and work with them to ensure that we answer any of their questions about subject matter expertise or process in order to help them process their complaints consistent with the federal requirements that we've established. And so if we go back to the previous slide, it also mentions that we administer what's called the request for review program. Once a state plan finishes its investigation, the whistleblower program at the federal level has an opportunity to take a look at that complaint if the complainant requests it. And there's some other requirements to qualify for that review program, but we are here to really serve as an appeal process for the state plan complaint investigation process, but only for safety and health complaints. None of the other federal statutes that we talked about are statutes that the states investigate. Those are the statutes that we investigate at the federal level. So the review program of state investigations only applies to safety and health investigations. We also implement outreach strategies, and as I mentioned, this is part of our outreach strategy. This is Safe and Sound Week, but it's also the 30th of July was Whistleblower Appreciation, National Whistleblower Appreciation Day. So really in recognition of both those initiatives, that's why we reached out to the Education Center and offered to do this Whistleblower 101 presentation. So that's part of our outreach strategy. But we also reach out to employers and various employee groups to try to explain what the rights are, what the process is, what we do as an agency to work to help achieve our mission and goals. We also coordinate with partner agencies. I may have mentioned that term a few minutes ago. And let me give you an example. So one of the financial statutes that we enforce is the Sarbanes-Oxley Act. And the Sarbanes-Oxley Act contains a whistleblower provision that tasks OSHA with investigating potential retaliation complaints for having reported any kind of securities fraud or shareholder fraud by companies that are publicly traded. The Sarbanes-Oxley Act itself is not OSHA's statute to enforce, only the whistleblower retaliation provision. Really, the Securities and Exchange Commission is the federal agency that has primary enforcement responsibility for the Sarbanes-Oxley Act. So we consider them our partner agency, and we work with them to ensure that each agency is fulfilling its mission under the statute, and where there's overlap in our jurisdiction, we coordinate with those partner agencies to make sure that we are working with them either to defer to their action or to coordinate ours with them in the best interest of the complainants to try to achieve the program objectives of protecting the workers. But we also respond to information requests. As a federal agency, everything we do needs to be subject to public disclosure and accountability. We work for the taxpayers, and so we're, even though we're an investigative component within OSHA. Our records are subject to public availability once an investigation is complete, and that process is the Federal Freedom of Information Act. And then finally, we engage in rulemaking and we develop policy documents in conjunction with our headquarters Directorate of Whistleblower Protection Programs and other components to try to ensure that we are meeting Congress's intent. Whatever the statute says that Congress has directed us to do, we need to develop our policy documents and our federal regulations consistent with congressional intent and our statutory charge. So even out in the field, we are participating in those processes to ensure that we're performing our whistleblower program functions as intended by Congress. And then the last thing that we do is we're a very data-driven organization, even on the whistleblower side. And so we compile and we analyze data to ensure that we are measuring our performance, our productivity, our quality and our efficiency, all key performance indicators. And we're measuring the right things, and we're measuring them in the right way to ensure that if we need to make adjustments to perform better for the taxpayers, we're doing that. And that's a constant. That's a weekly, monthly, and quarterly review of different statistics and data to ensure that we're doing our job the way we should be doing it. So if I could take you back to slide 8, which I skipped, and I apologize for that. I want to give you a sense of, okay, so what does this really mean nationwide and within Region 9? How many investigations did we docket over the years? And so these are some statistics that I pulled together from fiscal year 2020 until really the end of July of 2023. And so you can see the numbers here. And one thing that should jump out at you is fiscal year 2020, right? There was a little incident that happened in fiscal 2020 called the pandemic that sort of drove numbers through the roof. And as people had substantial changes in their work environment, I think, causally related to or connected to the pandemic, that really drove the numbers up that year. And that year is an anomaly because you can see it sort of dropped in 21 and 22. It increased. 23, we're on par with 22, maybe a somewhat of a 10% increase. So we had a big spike in 20. It kind of normalized in 2021, and it's steadily increasing from 22 to 23. So that's nationwide. When you look at the Region 9 specific numbers, these numbers are just cases that we docketed for investigation. These are the cases that met the criteria to warrant an investigation. And so to put these numbers in perspective, I have 5 investigators, 1 supervisory investigator, and then myself. Our entire team for the region is 7 people. And we've been as high as 9 people in my tenure, but we're down to 7 now. And when we get to the challenges slide, I'll talk about budget constraints and staffing and what that future looks like. But just so that you have a sense of how big is the program and what's the volume of work that's coming in. And I think that another thing that should jump out is the statutes are summarized by their acronym. OSHA means 11C, safety and health. So you can see that the number 1 complaint we receive is a safety and health complaint. And then the other thing that you can see is when you look at the data for Region 9, again, OSHA leads the charge, but SOX and STA, which is surface transportation, really commercial vehicles like truck drivers and things like that, those are our top categories for complaints. And so the types of complaints you receive in the whistleblower protection program really does depend on where you're at in the country and what types of industries are within your region. And so Region 9 actually gets a much higher number of SOX complaints, again, Sarbanes-Oxley, financial crimes, right, than some other regions, because we have major financial centers in San Francisco, Los Angeles, Silicon Valley, areas like that. If I broke these numbers down even further by state, you would see that California leads the charge, and the other states in Region 9 are really not on par with California. So California is our top driver. It's the most populous state, and so we receive far more complaints out of California than we tend to from any of the other states. Okay, if we could resume with regional offices, I've given you an idea of what our team looks like in Region 9, but there are 10 regional offices. And so this link right here is where you can get to the other regional offices. So if you happen to be looking at an issue that you think is crosses regions, and you need to look up information for that regional office, here's a link where you can find those other regional offices. The other thing that's important to note is that there are really 3 different types of state plans. And so within Region 9, all 4 Region 9 states are state plan states, but that's not true for other regions around the country. There are really 26 state plans, with I think Massachusetts being the most recent addition to the state plan states. And you can also find that information at this link, where it'll help you find information about what type of state plan the state plan is in your state. And why does that matter? Mostly because of coverage. The different state plans have elected to cover different types of employees. And so that's the biggest distinction between state plans, is that they don't all cover the same types of employees. For federal OSHA, we cover private sector employees, with one notable exception, and that is federal employees who work for the U.S. Postal Service can file their safety and health complaints and other complaints with us, and we have jurisdiction to investigate them. All other federal employees, we do not have the jurisdiction to investigate their complaints. And so if you're a safety and health professional advising a private sector employer, and you're trying to figure out, which state, is it federal, is it state? These are resources that you can use to sort of help figure those threshold questions out in terms of who you're going to deal with in this process.
Matthew, just so you know, we have a question from our attendees that says the 67 OSHA complaints in Region 9 include complaints to the state level OSHA, like Cal OSHA, ADOSH, et cetera. Are those all included in that OSHA configuration?
That's a great question, and the answer is no. These are only the ones that we kept and we investigated. And so I can give you some statistics off the top of my head. Each year, we receive about 2,000 complaints, and we'll refer about 60% of those to the state to investigate under its safety and health 11C equivalent state law. And so it's a fair number. And I'm very sympathetic to the states and their their teams, because even though we were overwhelmed at the federal level and have a pretty high volume of new cases and cases that we docket and investigate, the states have it far worse. And so that's why, even though we're in a role of regulating the states, we also, partner with them, to try to help achieve efficiencies, because they're just as slammed, if not worse, in terms of limited resources, the ability to hire and staff up, and other factors. So great question. The statistics I showed are just the cases that we kept with my team at the federal level, or the other regions at the federal level. And these numbers do not include the number of cases that we referred to the states for them, for their teams to investigate. Okay, so next we should look at how can employees file complaints. And actually the short answer is by any means available. And so in any language, verbally, writing, via our online whistleblowers.gov complaint page, it really doesn't matter. And so, our federal standards are, we'll accept a complaint any way it comes in the door. And so if you write a letter to OSHA, or you send an email to ask the secretary, and we look at it, we think it's a complaint, we're going to open up a case, we're going to screen it, and we're going to contact you and try to determine whether or not it meets the criteria for us to conduct a full investigation. And so we always err on the side of trying to process it as if it was an attempt to file a whistleblower retaliation complaint. And the reason why we do that is because we recognize that most employees really don't know the process or their rights. And so erring on the side of caution, we think is the right way to achieve the program objectives, although a federal requirement that my team has to abide by is neutrality. We don't favor complainants, we don't favor respondents, meaning we don't favor the employees, we don't favor the employers. Our sole charge is to remain neutral and to investigate a case and allow the evidence to really dictate the outcome in terms of if it meets the legal standard, that'll drive the decision making. And so, but at the outset of that process, we do err on the side of treating everything as if it is a complaint until we rule out that it's not. And so you can even visit a local OSHA office. I'm in the office today here in San Diego. The office is maintained and there's a duty officer 24/7, and there's functional email accounts. So you can call, you can email. We'll take complaints any way they come in the door. A lot of times, if we get somebody who writes they're a member of Congress, we'll have that referred to us, and we'll even treat that as a potential complaint that needs to be screened and processed as if it is a complaint, until we rule it out that the person really doesn't want us to be involved and investigate. So looking at really the mechanics, let's take a look at it in the context of Section 11C of the OSHA Act. Okay. The statute basically says an employer may not take an adverse action against an employee because the employee engaged in protected activity. And so here's your first definition, right? Protected activity includes, but is not limited to, reporting health and safety concerns to management, reporting work-related injury or illness, requesting copy of OSHA regulations, contacting OSHA, or participating in an OSHA inspection. Now, this is just for 11C of the OSHA Act. This is not the list of protected activities for any other statute of the 25 statutes that OSHA is charged with enforcing. Okay, we're only looking at, in the context of an 11C of the OSHA Act complaint, including safety and health, what are the classic protected activities that have been defined in the statute and otherwise. And so what we look for when we do get a complaint is what we call the prima facie elements. Prima facie literally means on its face. And so there are 4 elements that we have to establish, and really the complainant has to prove in order to prove retaliation. And those elements are protected activity, employer knowledge, adverse action, and nexus. We already talked about protected activity, but again, here are some additional examples of protected activities. And I gave an alternate definition earlier in the presentation that it was kind of embedded in the definition of workplace retaliation. But here are some additional examples of protected activity. But this is the first element that we look for when you contact us and you say, hey, look, something's wrong. And, I'm upset with my employer because they did X. We'll look at, okay, well, if all of that is true, did the employee engage in protected activity? The second element we'll look at is adverse action. In the earlier example I gave, which is the easiest, is somebody, the employer fired you. But adverse action can be very difficult and not as easy as you got fired. Okay, and so really, it's anything that might dissuade a reasonable employee from blowing the whistle, from engaging in that protected activity. And so we look at the totality of the circumstances to try to determine whether or not a reasonable employee in that person's position with that person otherwise would have viewed what the employer did as, dissuading them from reporting the injury or the illness or reporting the unsafe condition. If a reasonable employee says, well, I'm not gonna make that report, I'm going to get fired, or I'm going to get denied overtime, or I'm going to get shifted to the night shift, or worse, if they're on night shift and they get night shift differential pay, I'm going to get shifted to day shift and lose my night shift differential pay. And all of a sudden I won't be able to afford my mortgage or my daycare. And I've actually seen that. And that's not your straightforward example of an adverse action, but that's definitely something that's adverse, a change in your work conditions that reasonably would dissuade a reasonable employee from reporting the wrongdoing. So that's adverse action. The next thing we look at is nexus. And basically nexus is just a connection. We have to find some sort of connection between the employee's protected activity and the employer's decision to move you from the night shift to the day shift. There's got to be some sort of causal link. And so when we look at this, we look at a number of different evidence-based factors, but we also have to look at the different statutes, because under 11C for safety and health, we have to apply what's called the but-for causation standard. And so that's the highest standard of the 3 standards that are listed here on this slide. And basically, in order for the complainant, to succeed in the retaliation complaint, the complainant has to prove that the complainant would not have been transferred to the day shift, but for the fact that he or she or they had, pointed out and complained about an unsafe condition at work. And that's a very high standard to meet. Motivating factor and contributing factor are lower standards. Those standards apply to some of the other statutes that we have jurisdiction to enforce. But you have to have all four elements present in order to succeed in a whistleblower retaliation complaint. The next thing that we really should talk about is right to refuse a task. People ask generally, well, how do I know if I have a valid whistleblower retaliation complaint? And the answer is you have to have all four of those prima facie elements. And usually, and quite often, the conversation turns to, well, how do I know if I engaged in a protected activity? I thought, what I was being asked to do was illegal or unsafe, and I refused to do it, and I got fired. So it's a really great question because as you read through this slide, you'll see that the criteria to qualify for whistleblower protection when you've refused to perform a task is very high. You have to have a reasonable apprehension of death or serious injury. So it can't be a garden variety safety issue. It's got to be one that a reasonable person would recognize as, if I do that, I could be killed or lose an arm. That's the level that we're looking at in order for you to be protected under the law if you refuse to perform an assigned task. But you also have to refuse it in good faith. You have to have no reasonable or safe alternative, and you have to, really inform your employer and giving your employer an opportunity to correct it. If there's not time for either your employer or federal or state agency to get involved and correct the condition or the situation, then you may be protected under the law. So I always try to include this slide in the presentation also because it seems to be when you have workplace conflicts and employees disagree with employers because they think something is unsafe or illegal, so on and so forth. It's really important that workers understand that in order to refuse a task, you have to meet certain criteria, to legally be protected under the law, and they're pretty significant criteria. So I always want to, ensure that workers are advised and understand that unless it's serious, injury or death, and there are some nuances for like financial crimes and things like that. It's generally better to de-escalate the conflict with your employer and try to work through it and allow them an opportunity to address your concerns. And a lot of times employers will work with you to address your concerns. And they do have an obligation to show that they're not ignoring your concerns. They need to show that if it's really not an unsafe condition, they need to show you how and why that's the case.
Matthew, we have a question from participants. It says, while many employers may not immediately fire an employee for making an OSHA complaint, but what about the long-term actions by denying promotions or advancements? The latter seems almost impossible to prove by the employee, especially after a year or more. So how does an affected employee prove that he or she is still being targeted?
That's a great question. And I like how it was even asked because it is the employer's burden to prove. And so, and as a case gets longer in the tooth in terms of the date between when, the employee engaged in the protected activity and suffered the adverse action, it's definitely harder to prove. Now, when I worked for the TSA in the Title VII environment, Title VII case law recognized that even up to 2 years, you could still prove that nexus or that connection. But in, the whistleblower arena, really after about 3 months, it gets extremely difficult with timing alone to prove nexus. But when my investigators investigate a case, they don't look at just timing. They look at a multitude of factors in addition to timing. So they'll look at disparate treatment. They'll look at animosity or animus towards the protected activity, not necessarily animus or animosity towards the individual complainant, but really the protected activity itself. And so, and what's a good example of that with the Postal Service? We see oftentimes, there's evidence that that a management official, really didn't support the safety form that, mitigating the safety hazard that was reported on the safety form. That we would consider animus towards the protected activity and not necessarily the individual. But, and then we look at the consistency of the employer's response to why it took the action that it took. And so if the evidence doesn't support it, or they don't consistently apply their workplace rules for that were implicated by the situation, we would view that as either disparate treatment or wavering explanations for their legitimate business reason that they've offered, and we would find it not to be legitimate, pretextual, and establish nexus based on that same evidence. And so that's called testing the employer's defense. And so we don't just look at timing alone, but the person who asked the question is absolutely right. It's really difficult, the older a case is, in terms of the delay between the actual protected activity, when you reported the safety concern, and when you were denied that promotion. And so it's not impossible. It's just much, much harder. And ultimately, if we're unable to prove it by preponderant evidence and still meet that but-for causation standard, the case could fail. Probably a good time to sort of mention that year in, year out, we find merit in about 20 to 25% of the cases that we investigate. And so I'm sure the audience is kind of all over the map with, wow, that's really high, or wow, that's really low. And you would be right in both cases. It seems counterintuitive, but we really shouldn't have 25% merit cases, because that's really not a good sign that our work environment is what it should be, right? Or you could be from the perspective of saying, wow, of all the cases they investigate, how come they can only, prove, 20 to 25%? And the answer is, in my opinion, we have very limited subpoena power. And so a lot of these investigations truly depend on the voluntary disclosure of the employer. And think of it this way also. If you got fired, you got walked off the premises because the day before you said, well, I think if we file that report with the SEC, that's fraud. What are the chances you're actually going to have the evidence, that you may even know exists, your opportunity to collect evidence before you head out the door, and to do it in a way that's legal and consistent with your employer's rules, is significantly challenged, right? You're at a disadvantage. And so sometimes we can't change that dynamic just with our investigation, and we're unable to get the evidence, even if it may exist. And so it's really frustrating and disappointing, but there's, again, with our principle of neutrality that we have to maintain, we can only get to a certain point in an investigation. And then when we've exhausted our ability to collect additional evidence that may be relevant and maybe material to the decision as to whether or not retaliation occurred. We have to call it and close the case as non-meritorious. And so that's probably the number one thing that I deal with my investigators. That's a challenge because they feel personally and emotionally that retaliation occurred, but they can't prove it. And our job is to remain neutral and make a decision based on the evidence that we can obtain when we get to the end of our investigative steps. And so, but we're human beings. And so it's very difficult, especially when somebody's out of work, they're trying to put food on the table, they're trying to, pay their rent or their mortgage. They're not able to find, new work right away. These factors weigh on my team. They really do. So great question. I hope I answered it. I'm sure I went way beyond it, but into other areas, but that leads us to the investigation steps.
Hey, Matthew, before you get started on that, there's several questions, and I think this is maybe a good time that we could ask some of those.
Perfect.
Yeah. All licensed nuclear or patent licensed nuclear power plants under the jurisdiction of NRC, we are informed often that we can bring nuclear safety issues directly to the NRC without retaliation. However, for non-nuclear or radiological safety hazards, the MOU between OSHA and NRC, it's perfectly clear that OSHA has sole jurisdiction over industrial safety hazards per 29 CFR. And then it keeps going saying, however, it is not well known by workers at nuclear plants that they too can also go to OSHA for industrial safety complaints without retaliation. Can OSHA start reaching out to the nuclear industry to ensure this is clearly understood by nuclear workers?
Absolutely. And I think that was the hardest question I've ever received on this job. Because I haven't received a single complaint. And the answer is yes, we have one statute, I believe, that covers the nuclear industry. And because I've never had a complaint on it, I don't know that one very well. So you cited regulations that I've never, looked up. I don't even know if we have a desk aid. And so that term desk aid, our OSHA, really our Department of Labor attorneys, for the statutes, when Congress passes a new statute and adds to our jurisdiction, our attorneys try to put together a guide for us on how to investigate those particular statutes. I don't know if there is a desk aid for the one nuclear industry statute that I think is out there. But everything you said in your question strikes me as exactly correct, that you absolutely can come directly to OSHA without the fear of retaliation for certain aspects. The NRC may be our partner agency and may have sole jurisdiction over some aspects. Remember, they're the primary for enforcing the statute. We probably only have the whistleblower provision, but all the other issues, they have the enforcement, for those matters. Think of it, if you understand that, the compliance, safety, health officers are COSHAs, right? They're the ones who do the safety and health enforcement, right? My whistleblower investigator cannot investigate a safety complaint, right? Well, we also cannot investigate a complaint that might violate a provision of the NRC, of the statute that the NRC enforces. We can only investigate the provision for whistleblower retaliation and work with the partner agency to coordinate on those other matters. And so, but to your ultimate ask, can we reach out to the industry and do a better job of really forming an alliance with them as a partner? It's exactly what we do. And if your opinion is that there's a gap in the knowledge and understanding, of where those dividing lines are with workers' rights and, how we work with the NRC to cover all aspects of those statutes. That's a perfect example of where we should be reaching out to them and saying, hey, how can we, form an alliance with you and help build that knowledge, from top to bottom, because, if you invest in your workers and you build safety as a core value within your work environment, which in the nuclear industry, being a Navy officer, I know darn well that, they're uber about, compliance and so safety as a core value aligns with their interests, and we should be working with them. Okay, so if we can get to the other questions, I've covered a lot of the investigative steps as I covered some of the other concepts. And so let's try to hit as many of the questions as we can with the time remaining.
Yes, so we have one other one. I will mention the individual that did ask the previous question did put a link to the memorandum of understanding in the chat that we can get to, Matthew. So the other question is, does this overlap with EEOC/CDR oversight of retaliation complaints? And before I let you answer that, just wanted to let you all know we are going to answer this question, let Matthew finish his presentation. So we might be going over a few minutes, but we'll love to have you stick with us. So Matthew, does this overlap with EEOC/CDR oversight of retaliation complaints?
So before December of last year, I would have said no, but Congress changed the Seamen's Protection Act, SPA, in December, and for the very first time added to OSHA's jurisdiction retaliation complaints for reporting sexual harassment. And so that's the only overlap. All other Title VII issues, race, religion, gender, all of the classic protected classes and retaliation for engaging in protected activity related to those protected classes belong to the EEOC. We would lack jurisdiction and refer it to them. Okay, so really quickly, the key thing in the investigative steps is that we work with both parties to try to get to enough evidence to make a decision. If we get to a merit determination, we're going to grant certain relief. And so what's appropriate in terms of relief is dependent on the statute that we're investigating. And so it may be reinstatement, it may be punitive damages, it may not be. And so each statute has its own limitations, and that's why that statute summary chart is really helpful, because even I don't take a chance when I'm closing out a case and approving a merit determination. Always go back to the statute summary chart and make sure that we're not overlooking an appropriate remedy or trying to award a remedy that's not allowable under the statute. There are other ways for us to settle complaints. And I think it's important for the audience to understand that we try to engage in settlement as much as we can. Okay. And so even though my investigators are charged with being neutral, we are available as a resource to the parties to try to help them reach an agreement with the case at any stage of the investigation. We don't have to wait until we've gathered enough evidence to make a determination. At any stage of the investigation, we can work with the parties to try to reach an agreement. There are limits. The slides really just try to flesh out some of the limitations of what things we will approve, what things we will not approve. And then also there is alternative dispute resolution available. Now, what's the difference between one of my investigators trying to work with the parties to settle the case versus a formal alternative dispute resolution mediator? the ADR mediator cannot investigate the case. So anything that's provided during ADR will not be provided to one of my investigators. And so some parties opt for that because of the confidentiality, but others are comfortable working with the investigator and trying to just resolve it and move on. We settle a lot of cases, which is really a good thing. And then finally, we conduct outreach to employers through fact sheets, wallet cards, presentations, and then alliance programs like we talked about, and other similar types of outreach to employers. And we help employers to understand that there really are recommended practices for implementing anti-retaliation programs that proactively prevent these things from occurring. Because even though this is really the analysis is a deliberate or intentional discrimination type analysis, honestly, a lot of these situations arise because they just didn't have good practices in place to process the concern the employee raised from the beginning. And so that lack of recommended practices being, in place ultimately can lead to an intentional discrimination finding that, you retaliated against an employee. And it honestly, it can be avoided. And so, so we try to help do that too, because really the goal is to create a work environment that is safe and healthy, and workers can report, problems without, fearing that they're going to lose their job. And with that, our challenges are our staffing level, as I mentioned, but also our inability to just kick the door down and grab all the evidence we think might be out there. That's just not the way this type of an investigation works. It's a collaborative process. It's civil. It's one in which we really do rely on, participation and good faith, responses. But also, the complexity of the subject matter and the differences of this in the statutes. We're constantly having to go back and double check our work to make sure that we've got it right. And we just don't have a lot of experience with every single statute that we have. And so if there's any more time and any more questions, I'm happy to answer them, but that covered the remaining substance of the presentation. I know I went a little fast in the end there.
Thank you, Matthew. We do have another question. In October of 2022, my employer said I was under investigation. To this date, I have not been told the investigation has concluded. Is there a time limit for city entities to conduct investigations? When handed a retaliation information packet by my city employer, I was given the option to file a complaint to the state or Fed or city personnel. I don't trust our internal personnel department, so what questions should I ask myself in order to know if I should file a complaint with state or federal? Can I have a simultaneous ongoing labor law attorney handling a civil case?
It's difficult to have the simultaneous private right of action. And in the challenges slide, only about 1/3 of our statutes allow for a private right of action. And so, and we also call it a kick-out provision. So, and there's different timelines on kick-out. Some statutes, it's 210 days. In other words, Congress has said, look, if it's this statute and OSHA has jurisdiction, you have to let us have 210 days minimum to try to investigate. Then you can get tired of us and go to private court. There are others that are far fewer than 210 days or far less of a time period. But the other complicating factor is that you're a city employee. And I don't know the underlying statute that it might be, but my advice would be go online at whistleblowers.gov, file an online complaint with federal OSHA, because we'll screen it and determine whether or not, your state has jurisdiction And if so, we'll send it to the state. But it might be premature. You know, you may not have suffered an adverse action. An employer's investigation in and of itself is not necessarily a material adverse action. Employer has a right to investigate alleged misconduct, right? Now, if they do it in a time, place, and manner that changes the analysis, that could be an adverse action, because if they're doing it publicly and they're shaming you, that's not acceptable. If they're doing it professionally and privately and consistent with their workplace rules, then that's acceptable. As a city employee, you almost certainly have a master labor agreement, and the duration might be covered by it, might not. I haven't seen a whole lot of them that say they only have 6 weeks or 6 days to conduct their investigation. Could you allege that, an open-ended investigation itself is an adverse action? We would listen to that argument. We would look at the totality of the circumstances and say, would a reasonable employee think, man, 3 days after I reported that the CFO is, signing things that I think are fraudulent, I got told I'm under investigation, and here it is 3 years later, and I'm not eligible for promotion while I'm under investigation. That's an adverse action. Any other
Thank you.
questions?
Yeah, one other question. Is there a flow chart to help us learn which agency we should choose to file a complaint with?
It's a great question, especially for California, because I was born and raised here, 54 years old, and I still can't figure out California state government. So, again, the simple answer is file with us. And part of my team's job is to troubleshoot based on the information you provide. First and foremost, which state, right? But then if it's not us, which state agency is best? California Civil Rights Division, DLSE, Cal OSHA, amongst the various components and entities in each state, my team is experienced in trying to, steer you in the right direction. And, even if you're premature, you're at least protecting your rights from a timeline standpoint. Because remember, for OSHA's 11C, you only have 30 days from the date of the adverse action. Okay. So if they issue you a letter of reprimand on August 1st, you have 30 days to file with us to be timely. If you don't, and you wait until they suspend you 8 weeks later, we can't consider the earlier adverse action. We can only go based on the more recent one. And so it does impact our ability and your legal rights. And, so you're better erring on the side of caution and filing and being told you're premature than not. But, once you file, we'll look at it and we'll try to determine, if it's not us, what state agency, is the right one, and other federal agencies, because like federal EEOC may kick it to the state, they may not. We would recommend both California Civil Rights Division and federal EEOC and let them decide. But that's what we would recommend to you. We give it to you in writing and how to contact.
All right, thank you. We have one other question. Do you offer a PDF of this course? I will mention we are recording this session, and will be posted on the OSHA Education Center site in the next few days that you can find this there. You will see all of our contact information on the screen. And if we don't have any other questions, Matthew, any final words?
I would just like to offer that if questions come up afterwards, either because you didn't get a chance to ask it or you thought of it later, please channel it to your particular education center. I think there's great value in the education center having visibility on whether the audience is getting value out of this. And I'm happy to answer anything that comes through. So normally I just offer, hey, here's my contact info, contact me directly. But then the education center wouldn't see, whether or not, and to me, it's a measure of whether or not, you guys gained anything out of this session today. And so if you don't mind, please channel it through your education center, and then they can push it to me, and I'll answer it. Other than that, I'll end where I started. Thank you for giving this. You guys were like the best audience ever. You asked not only the most questions, but like really, really serious questions, and that means something to me because within OSHA, the whistleblower program, we feel like we're the tail, and the safety and health side of the agency is the dog. Now, we're really like a Chihuahua. There's only 2,200 employees in the entire agency in OSHA, and by contrast, TSA at LAX in San Diego, and I was counsel for TSA at San Diego, they have about 2,000 employees just at those two airports. And so we rely on safety professionals and safety trained individuals, to get the goal met. And so I just can't tell you how much I appreciate you taking this seriously and really making it worth, at least my time. Made me feel like this was time well spent, and I'm happy to come back and do it again.
Thank you. Well, we appreciate all of you being with us and sticking with us a few extra minutes. We can stick on for a few more minutes if there's any questions. Otherwise, we'll see you on our next webinar. Have a great afternoon.
And I'll stay online as long as necessary also.
Matthew, there is a comment. If it's any consolation, I have a Chihuahua and we love her. So
I had two. I got them in Mexico when I was on exchange there with the Navy. I taught English at the Mexican Naval Academy for 2 years. And and really it was between, I wanted to get a Mexican dog, and it was the hairless or the Chihuahua. And the Chihuahua was hands down. I was not going to get a Mexican hairless dog. They're a very unique breed, but I appreciate that comment.
We have a question. Is there a certificate for this class or proof for our employer of a participation?
It's a great question. I don't know if OSHA has, let me look into that, because I'm certainly happy to, provide it. And I'm sure that the region administrator, Jim Wolf, would be happy, if it's within his discretion and authority to recognize as an informal, training, I'm sure he'd be happy to do it. So I'll get back to you on that one. I think I owe you the nuclear industry question as well. So I'm tracking at least 2 IOUs, the training cert and the nuclear industry question. Is there anything else that the team remembers?
I think that was it.